इसको चेंज करना होगा. Yes.
From supplementary list, item number 1.
Please, Lordship. This PI can be closed on the in view of the order dated 21/07/2025 passed by this Honorable Court, Your Lordship. Because in the order, it has detailedly that they have make a clear observation in this court. So I'm satisfied with the order. So that
Order.
this, in view of this order, that this
It was a pill.
this is the yes PIL with regards to the other insistence of other, where the government of Meghalaya have been insisting this citizen, the resident, to produce and register the Aadhaar card, whereby in the various judgment, this is stated that the Aadhaar card is not mandatory. In view of the order, is on the last occasion, 21/07/2025, whereby state has no objection. They have make a very clear observation in view of this order, this can be disposed of, Your Lordship, because
Which order?
this 21/07/2025, I have enclosed in my rejoinder affidavit, my lord. It is there, Lordship.
What is the rejoinder? Where is the rejoinder, man?
Otherwise, we have
Give a
the
copy.
order. This order. This is at page 6 of my agenda. This is also this there. This copy. The same. It is in the agenda. Only one. Oh, only this there. No, in the agenda.
So this order covers the issue.
My lord,
Yes.
this order is subsequently modified, my lord. Lordship kindly sees the order of 30th of August, my lord.
Order of
30th August.
30th August. Where do I get it?
38, my lord.
Where do I get it?
In the order sheet.
30th August. August.
The deed order also, my lord, is
My
the
lord, the
same
alternate
thing.
documents can be accepted only if a person has applied for Aadhaar card, my lord. Number has been assigned to him and it is under process and the Aadhaar card has not been issued to him, my lord. A person who opts not to apply for Aadhaar card, my lord, he will not be entitled to benefits, my lord.
So this Unique Identification Authority of India, they filed their affidavit before 21st July 2025. Because you said the Unique Identification Authority of India has filed its affidavit in opposition even before directions on that behalf were made by the court.
So, my lord, you kindly seize my affidavit, my lord. It's the affidavit to respond number 8, my lord. My Lord, sees para 8 of my affidavit at page 4.
No, see, voter identity card is your identification.
Well,
Aadhaar card, Supreme Court said it's not mandatory.
my Lord, but for the purpose of availing the direct benefit transfer and other benefits, my Lord.
You cannot have three different or two different sense of identification of a particular person.
My Lord, the matter has
Your
been.
voter ID card is a proof of his citizenship.
My Lord, why the provision has been made in Section 7 of the Aadhaar Act, my Lord, and upheld by the Supreme Court, my Lord. I was just pointing out that paragraph in Supreme Court decision, my Lord, page 7 of the affidavit, kindly says, my Lord. The Puttaswamy judgment, my Lord.
Before that, let us see what he's saying in affidavit. What is your affidavit? Affidavit, what is your affidavit?
Affidavit response number 8.
You are for the response number 8, the affidavit?
My Lord, unique identification authority, the Aadhaar authorities, my Lord.
Response number 8.
Yes, my Lord. Para 8, we have quoted Section 7 of the Act, my Lord. The Lordship kindly sees para 10, my Lord. We have quoted para 508 of the Puttaswamy judgment, my Lord. But the reason is, my Lord, the Aadhaar is integrated with the banking system, my Lord. Epic card and other proofs of identity are not integrated with the system, my Lord.
So they are applying for any subsidy.
Your Lordship.
But their case is, my Lord, without the Aadhaar card should not be insisted, and they should be entitled to the benefit without even Aadhaar card.
Your
My
Lordship.
Lord, our stand is, my Lord, Aadhaar card is one aspect, my Lord, and those who have even applied for Aadhaar card, they have not been issued Aadhaar card, they can avail of the benefit, but they must apply for it and get an application number.
Your Lordship, may I submit, our contention is that this Section 7, Your Lordship, number 1, the Section 7, the Puttaswamy judgment in para 1539.11, it has been declared arbitrarily and violation of Article 14 of the Constitution. That is there. Number one, the judgment is already clear. That section 7 has already been declared as arbitrarily and violation of Article 14 of the Constitution. That is very clear. And number two, we have the petitioner is a public interest litigation. I have never approached the authority for filing an application for issuance of Aadhaar card.
No, see, the person who is aggrieved, he has not approached us.
Yes.
What locus you have to challenge this? Any person who is aggrieved, it's not that all persons who are entitled to subsidy are poor. Why how do you espouse their interest?
Yes,
How you espouse their interest? Affect anyone
yes,
who is unable to get the benefit has not come before this court.
yes. May I
You are
submit
not a
your-
person aggrieved.
Yes. May I submit, Your Lordship? I'm saying this Aadhaar card is in fact is an optional. We are never saying that it should not be insist. We are the petitioner contention of the petitioner is it is an optional. Those who want to apply for Aadhaar card, they are
No, if you
legally
are-
they can apply, but they should only the contention of the petitioner is they should not insist the citizen or the individual who is not willing to register or accept the Aadhaar card. They should not insist. They should not force the citizen. That is the only condition. If the citizen individual who want to apply for the Aadhaar card, the petitioner have no problem. But only the contention of the petitioner is that those people, the Aadhaar card, they are fear of some individuals who don't want the Aadhaar card, who don't want to accept. It is their liberty.
No, it says that if anyone wants to avail
Yes.
subsidy, benefits and service, he has to have one Aadhaar card.
Yes, Lordship.
If
That's
he
why.
does not want the benefit, my lord, no one is forcing them to apply.
I
for
never make a statement. That is not my case, Your Lordship. He is misleading, my Lord. I'm only saying that Aadhaar card should not be insist on the individual who is not willing to obtain the Aadhaar card. That's all. I never say that.
No. Aadhaar card, they insist if you want to avail of any benefits of subsidy, not for anything else. It is not that if you don't have Aadhaar card, you cannot cast your vote. It's not that.
Yes. A second contention is
Because for a voter, you can carry your voter ID, and for casting your vote, Aadhaar card is not compulsory. It's optional. But if you want to avail of any subsidy, benefit or service,
otherwise, my Lord, in the order they have observed, Your Lordship, that any PAN card, election ID, that also can be taken considered for even for other service benefit also, my Lord. They have.
It is not clear what they want, my lord. Whether they want to benefit or they don't want benefit, even that is not clear. No submission.
if you read the judgment in 467 paragraph, which is quoted in the affidavit in opposition, residents are thus held entitled to obtain Aadhaar number. We may record here that such an enrollment is of voluntary nature. However, it becomes compulsory for those who seek to receive any subsidy, benefit or service under the welfare scheme of the government, expenditure whereof is to be met from the consolidated fund of India. It follows that authentication under section 7 would be required as a condition for receipt of a subsidy, benefit or service only when such a subsidy, benefit or service is taken care of by the consolidated fund of India. So is it out of consolidated fund of India? If it is not, then you cannot insist on that. In view of paragraph 467,
Yes, ma'am.
if this fund is coming out of the consolidated fund of India, then only you can insist for other. Otherwise, you not.
Well,
So you cannot insist for Aadhaar card if it is not, if this fund or this benefit, subsidy, is not taken care of by the consolidated fund of India.
My lord, my humble submission, my lord.
No, we go by 467 paragraph.
My lord, what the Supreme Court has done is upheld Section 7, my lord. Section 7 basically, if I take a lordship,
They have interpreted this. They say that, you see, they have said that in 309, which you have quoted in paragraph 18,
Yes, my lord.
that is other way, indirect way, you are making it compulsory, mandatory
Yes, my lord.
to avail a benefit. But then the rider is that if this fund is coming out from the Consolidated Fund of India, and then the scheme for the welfare scheme, the beneficiaries would be required as a condition of receipt to have the Aadhaar card.
Yes, my lord.
Aadhaar is voluntary in nature. So if you want to, provided it is coming out of the Consolidated Fund of India.
My lord.
If it is not coming out of the Consolidated Fund of India,
It
you
cannot
cannot
be
insist for the Aadhaar. So you have to
My lord,
see
it
that
appears now we have to examine which subsidies are coming out of
exactly. So
Consolidated Fund
we
of India.
cannot decide on this issue.
Yes, my lord.
So whenever this issue come up, this 467 has to be taken care of.
Yes, ma'am. So now we have to examine, my lord, whether LPG subsidy or direct
If it's
benefit
coming from
transfer
the Consolidated Fund of India, then of course
Yes, ma'am.
you insist. If it is not, then you can't insist on this. Simple as that.
So matter may be disposed of, my lord, in that direction.
In fact, this direction has to be modified. Your notification of 31st October 2023, is it the state notification or the
Yes,
central government
no, it is
notification?
a state notification.
Madam, you are appearing for the state.
I'm appearing for the statement.
See, the previous division bench direction was that, as far the notification is concerned, as an interim order, we direct the state government is at full liberty to insist on production of Aadhaar number or Aadhaar card from individuals for their speedy identification. If an individual is unable to produce an Aadhaar number or card or is unwilling to obtain Aadhaar single registration, then he would have to prove his identity as resident in terms of the state act from other recognized documents like PAN, voter card, passport, and so on. In that event, non-possession of the Aadhaar number or card would not be a disqualification. So now that this, if 467 as it reads,
Yes, my lord.
so it says that Aadhaar card would be applicable provided it is coming out from the Consolidated Fund of India. If suppose state is holding out any beneficial scheme, it is out of the state fund, not from the Consolidated Fund of India, then you may not require it for
Yes.
Aadhaar. Then whatever directions of
My lord,
the
in my consolidated fund of the state will be covered, my lord.
that's what I'm saying.
My lord.
So every fund is coming from the Consolidated Fund only. Unless is taken care of by the Consolidated Fund of India.
Because the Supreme Court only mentioned Consolidated Fund of India because, my lord, the issue must have been only the central subsidies, my lord. The previous para word used is exchequer, my lord. At page 12, my lord. If the affirmative action which costs the government and the money comes from exchequer, so it becomes the duty of the government to ensure that it goes to the deserving persons. The exchequer and consolidated fund will have again different meanings.
So, if an applicant make an application for enrollment but the other number is not assigned, then he can
avail
use
it.
another. That is section 7. You have the judgment of Puruswamy. Give us the judgment.
They have.
Bring the book from the library, no? Dissenting judgment was there.
Yes, you put on the whole paragraph.
What's the paragraph?
Which you
If you ship this, if you ship it for this, subsection of the judgment summarize. It's a majority judgment, Mr. Counsel. The majority judgment, paragraph 511, 13.1, 13.2, and 13.3. Answer the question. Answer the question, majority judgment. The majority judgment of section 7 is answered in paragraph 511.13.1, 511, 13.2, and 511, 13.3. It's already answered, so what we need to answer? It's already answered, so what we need to answer? And what is your notification, madam? Show us the notification.
My lord, that is at page 40, my lord. This is in respect
40.
of... My lord, 40 of the writ petition.
Just a minute.
Annexure 7, madam.
Four zero. Let's see. 40. Yes. You heard from the concept. This particular notification is not a subsidy.
It is scholarship, my lord. Scholarship. Post-matric scholarship.
Scholarship is some kind of
Fees compensation for post-matric scholarship for SC/ST students.
Now it says that it will only cover those benefits. The expenditure thereof has been drawn from the Consolidated Fund of India. Now it says it's Consolidated Fund of Meghalaya state.
Yes.
So if it is not coming because it's a central act, your act is a central act.
Yes, my lord.
It's a central act.
My lord.
So by reason of this 511 13.2, it's not coming out of your fund.
Yes, madam. This is from
My lord, the purport,
state.
purport will be, my lord, consolidated fund either of state and union.
It's very clear if we go by this judgment,
Yes, my lord.
the central statute, you are implementing a central statute, correct? It does not say that the state will have any such power. Unless this fund is drawn from the Constitutional Fund of India for the purpose of the schemes of benefits. This is a state notification.
Yes.
It is state notification, my lord.
And fund also from the
So
state.
whether the state can insist for other, for this purpose, that is the only issue.
Yes. That is a very vital question, my lord. That I think we'll have to read the judgment once again. My lord, I'll read the entire judgment, my lord. It is quite a lengthy judgment, my lord.
No, we go only by the majority judgment.
Yes, my lord.
That is of Dr. Shikri.
My lord.
Justice Bhushan, Ashok Bhushan, partly concurred, partly dissented. And Justice Chandrachud substantially dissented.
My lord.
From the majority judgment, you need to find out whether this would apply because, first of all, it says, as far as subsidies, services, and benefits are concerned, their scope is not to be unduly expanded, thereby widening the net of other, where it is not permitted otherwise.
My lord, if lordship comes to section 7 of the Act, my lord,
Yes,
section 7 of the Act talks about state also, my lord.
Section 7.
Other Act.
Yes, that was here only.
But are quoted at page 4, my lord.
It's here only. Yes.
Talks about consolidated fund of the state also, my lord.
This was amended.
In 2019.
So this is after the judgment, maybe, not
After-
prior to the judgment. This was amended on 20th
Effect from
July 2019.
25/7/19, and the judgment is of
This is 16. Judgment is on 19.
Must be prior to the judgment.
judgment is
After the judgment.
September 26, 18. my lord. It's 18 judgment.
Huh?
Judgment is of 18. my lord. Judgment of Putuswamy is of 18.
18, yes. So,
26 September 2018. my lord.
so this is a subsequent amendment. So consider for the state.
Yes.
Then of course that will be. This will be certainly a benefits, welfare benefits. That will come within the purview of this 511.13.2. Of course, this will be, you are having this other registration for the children.
Yes.
For that, you have to follow 512
Yes. Consent of the
paragraph.
parents.
Yes, see paragraph 5 to 1 to 512.6. So far the children are concerned. 512.6. We also clarify that no child shall be denied benefit of any of the schemes if, for some reasons, he is not able, she or he, whatever the child, is not able to produce the other number and the benefit shall be given by verifying the identity on the basis of any other documents. This we share having regard to the statement which was made by Mr. Venugopal, Learned Attorney General for India at the bar. 512.6.
100.6.
So for the children, you have to be guided by 512 point in bracket 3. So the state will be mutatis mutandis. The expression of the Attorney General there for India will be mutatis mutandis so far as the state is concerned. So we are considering for the children. So provision of 512 will come. Suppose the parents are unable to provide, then by reason of 512.6, so a separate category has been carved out for the children. And it is very clear that they should not be denied the benefit merely because the child is unable to produce Aadhaar number.
Yes. And child is defined at 18 years of age, my lord.
So yes, so till about 18,
Yes.
since this benefit is up to 18 only.
Yes.
So we dispose of this matter. So we dispose of this matter
Yes.
by directing the state to follow 512.6. Because you are giving it post matriculation, correct?
Yes, ma'am.
Yes, madam.
So that will be 16 to 18.
Yes.
So 512.6 will apply. And if already they have their identification when they are admitted in the school, why
not
you
a-
insist on this?
Yes, ma'am.
Say now. Child, in fact, defines up to 18. So,
That also depends.
Majority Act is different, but child is
Yes.
child.
Because the Act itself says already.
Yes.
Item number 2, my lord, I have the instruction from my client.
It's a child. On a post articulation will be applicable to what is it? I think that should be fair. For
Yes.
the child, you can't because he cannot age of consent.
Yes.
This is
Oh, sorry. Keep this, you may require this. Thank you.
Be-
Yes.
Yes, lordship. In item number 2, my lord, I have the instruction from my client that he is not interested to pursue the case further, my lord, as he has only 7 months left for retirement as a superannuation, my lord. So this is the instruction, my lord.
No, he is the appellant.
Yes, I am the appellant.
I'm
But
the-
here what
I'm
happened,
the respondent.
the respondent approached the learned single judge, my lord, for last leg posting of his choice, my lord. The learned single judge directed us to consider his case, my lord. We filed an appeal. Now the respondent, because only 7 months service is left for him, my lord. So he abandons his claim, my lord. He's saying that he's not interested since he's retiring very soon.
But normally all service rules provide, sir, that last leg he is entitled to hometown.
My lord, here the posting he was seeking, my lord, somebody else is serving there. And he's at a senior level, my lord. He's a second in command, deputy commandant. Had been case of normal constable, my lord, there are several posts, my lord.
Okay, now. But you have a written instruction.
Yes, my lord, I have submitted, my lord.
The learned counsel for the respondent, on the basis of a written instruction,
My lord.
dated 22nd October 2025, received from the writ petitioner, we made it clear that we have not decided. Yes.
Sir, this is an arbitration appeal under section 37, my lord, against the order passed by the Judge Commercial Court on section 34 application, my lord.
Appearing for the first time.
Before your lordship's coming for the first time, my lord. The appeal was admitted, my lord, is for ready for hearing otherwise, my lord.
You need to file an. You see that there is no. You have deposited the awarded amount.
50% we have deposited before the trial court because they filed execution petition, my lord, when section 34 was pending. So 50% of the amount we deposited before the trial court, my lord.
I see. There's a little surprise. Why not 100%? So they have encashed 45 lakhs.
Yes. They haven't cashed. You withdrawn the money?
But then you have to file an undertaking that in the event the appeal is allowed, you refund the amount. How you can appropriate? First of all, you should not have given a check. It's a court
We
deposit.
deposited in the court, my lord, before the trial court.
We have given an undertaking before
Undertaking
the trial.
before the trial court. Some kind of
Appeal to undertaking is there.
Yes, Lordship.
indemnity bond will be there, my lord.
Unit bond is there.
Yes, Lordship.
I see. You file your informal paper book.
We'll file it because otherwise, my lord, we have annexed most of the documents. Only one very short legal question, my lord. Our case is, my lord, the award published by the arbitrator is bereft of reason completely, my lord. My lord, what arbitrator does, my lord? Claim 50 lakh, okay, I think 25 lakh is good enough, awarded 25,000. Without any reasoning, without any evidence, without any finding on any of the issues, my lord. Loss of profit, he says 50 lakh rupees claim, okay, I give 25 lakh rupees.
What is the award?
My lord, I'll just take lordship to the award, my lord. Page 186, my lord.
186.
And my lord, the operative parts your lordship will see. Starting from
86.
well, we are mainly agreed with claim number 3, 4 and others, starting from page 192, my lord. Page 192, lordship kindly comes, my lord. Claim number 3, rent for machineries, non-issue.
Just a minute.
Also, kindly sees claim number 6 at page 193, my lord.
Yes, sir. Yes, sir.
Right.
The work was completed now.
Completed, Lordship.
The detailed reasoning is lacking. You should
Lordship.
have filed an application at the initial stage directing the arbitrator to furnish the reasons. That stage is over now.
But here what happened was in section 34 application, my lord, the learned trial court has set aside 2 awards, my lord. If I may just
Give the arbitration act, give the arbitration association. But this is a single award. This is a single award.
single. Are there multiple claims, my lord? 2 of the claims the learned trial court has set aside, my lord, on the same ground that there is no reasoning given.
Which one? Which are the two?
I'll just place, my lord, for your lord's convenience.
What it is?
Lordship, kindly have page, second page, my lord. Claim number 7 and claim number 8 have been set aside by the trial court, my lord.
Claim number 7 and claim number 8. Just a minute. No, that's fine. Very well.
Now, my lord, though I have challenged all the claims, my lord, but I am mainly on claim number 6, my lord. Your lordship only considers claim number 6. Case 193, my lord, of the paperwork, lordship kindly sees. Loss of profit due to delay. Arbitrator is awarded 15 lakh rupees, my lord.
To some extent, 4, 5, and 6 would be overlapping.
My lord. My lord, 6 is for profit due to delay, my lord. Now, only 2 sentences, my lord. Page 193, lordship says, my lord. There is no basis on what basis the learned arbitrator arrived at the figure, my lord. And without any evidence to that effect.
No, he said that one of the basic reasons for delay is delay in handing over the site.
My lord.
So if they are supposed to, during that period, they have to show that they have kept the machines oversight the site and everything. They kept it the idle machine, then labor,
Yes.
and then they kept the site prepared for the work.
Yes.
But for the delay, they could not start the work.
So, my lord, for that claim number, starting from claim number 1, 2, are all on different heads already awarded, my lord. Non-payment or escalated price of labor fuel,
So that's what I'm saying.
my lord.
Claim 6 should be already inbuilt in your 3 and 4,
Yes,
3, 4, 5,
Yes, my lord.
or rather even claim 2. Loss of profit would be.
Lordship 3 is different, Lordship, that is Schedule C. They have not issued that item totally. Because, Lordship, Arunachal Pradesh is a hilly area.
No, but no, they have not. They are supposed to give this machine to you under the
Yes,
contract,
Lordship, they are supposed to supply to me.
and you have completed the job.
Lordship, we have
Then
completed
3
the
is
job.
fine. Then 3 is no problem.
And Lordship, regarding the setting aside of claim number 7, Lordship, reduction of labor welfare cess. Lordship, this was deducted by them, and in my reply, Lordship, the last annexure, that is
No, but you have not preferred any cross appeal.
cross appeal, because they had filed the appeal, so I came up with a reply only.
No, but you have no. There's a cross appeal on this. We cannot decide on this. In a reply, is not.
No, the setting aside itself is wrong, Lordship, because a thing cannot be deducted twice.
You have not challenged the order of the learned single judge. There is no challenge to the order. So we are today presently deciding.
No, Lordship, it was in the trial court. I had compared. It was not before a single judge. It came
Yes,
directly before the
single judge
division
means the
bench.
trial court. So Section 34 court has partly allowed their application for setting aside of the award.
Yes.
Against that, you have not challenged any appeal. The appeal
No,
is by
I have
them.
not come here because they have come before.
So we cannot go into the question whether 7 and 8 was rightly decided or wrongly decided. So today you are left with 1 to 6. 1 to 6?
Lordship, only one letter is sufficient for everything, Lordship. I'll just read out that in my reply. That is page number 115. Letter by the department. Lordship, had there been a delay from my side, Lordship, they would have put me with LD, liquidated damage. But now they had dragged this matter till 2012, an 18-month contract.
115
115, Lordship,
of the
of my reply. Annexure 30. Reply to the owner. This is to the respondent, MS Karki's Construction, dated 28th November 2012. It is by the garrison engineer. Reference this. Para-wise reply of above referred letter I raise under. Para number 2. The point has already been regretted by this office-wide office this. But again, your firm has highlighted the same issue. That is regarding the loss of loss of profit. Refer clause number 18.5.2.1 of Manual on Contracts 2000 payment can be made again if a considerable amount is due against the contractor. So you can place another running account receipt RAR for payment along with any other additional work done which is due against your firm for above mentioned work in case you desire. So RAR was never clear to me. As per notification that this issued by Office of the Assessing Officer, Cess Collector, West Command, Tawang District, Bomdila, Government of Arunachal Pradesh, Labour Welfare shares at a rate 1% will be applicable with effect April 2007, and hence the same was deducted against the RAR payment due to your firm. The appropriate Labour Welfare Cess Collector may please be asked to refund the taxes directly related to contract value as mentioned in clause this, as the amount was deducted as Labour Welfare Cess has already been deposited to the concerned department immediately on deduction. So now they are directing me to go to the Office of the Labour Welfare Cess to take that money. Then para number 3, DO for provision of vitrified tiles in lieu of quota stone in admin block of this much, that is the plus DO, has already been forwarded to the headquarters CWE Tejpur for scrutiny onwards on submission. On star-rated, due to certain, Lordship, I'll go to para number 4. It is a fact that due to non-availability of tube light fittings, the work was delayed and extension of time on this account was also granted. Lordship, they are accepting that there is delay. Yes, there is delay. But I have been working, not running away.
Tube light fittings are to be supplied.
No, this is just one of the Schedule B item.
Which
Now,
you are
Schedule
supposed
C
to
also
supply.
they would like.
They have given you extension.
Yes, extension was granted. DO was issued, that is last DO, that is 17th number of DO. That was issued, copy of deviation order, page 80. That was issued
Would
on
not be fit to your
2012.
form.
Last deviation order was one on 2010, July. So there were at least 17 deviation orders in this particular contract of 18 months. And above that, loss of they could not give us the site. There was delay in site. There was stop of work done by the department. They stopped the work for a month, whereas my labor, my everything was lying there in Bomdila. And Bomdila,
But
Lordship,
have you
is
given any
very
proof?
far.
Have you given any proof of that?
Yes, Lordship. Every proof, in fact, they have also stated.
Well,
Lordship, I am coming to that. Proposed site was not handed over till 27th January 2009. 2008 contract was given to me. December. And on-site work started from 2nd of February 2009. Page number 2 of my reply, Your Honor, along with documents annexed, Annexure 1. Page number 13 is the annexure regarding handover of work site not handed over. And page number 14 is their letter, the
the
department.
contract price was 98 lakhs.
Lordship.
You have received 1 crore 4 lakhs.
Yes,
You have
Lordship.
received 1 crore 4 lakhs.
Lordship.
Now an arbitrator awarded.
Then deductions were there,
Roughly 90 lakh rupees.
90 lakhs.
90.
Deductions were there. They had deducted from the final bill was not issued, Lordship. Those RAR only the payment had. Lastly, final bill they never cleared up.
No, total contract value was 98 lakhs.
Yes, 98 lakhs,
Rather 99 lakhs.
almost.
You received 1 crore 4 lakhs. You received 1 crore 4 lakhs
Yes, Lordship.
more than the contract value.
Yes, Lordship.
You have received 1 crore 4 lakhs under protest.
Under protest, Lord.
So, where is your claim statement page?
My claim, I think you have not made a part.
You have not given the claim petition.
My original claim, they have not made a part.
The
I think.
claims, page 49 is what?
Page?
Original claim before the arbitrator.
Yes, that
But
is
that
required.
has not been made a part of it, I think, Lordship. They have not made a part of it.
You better file an, you see, not basically what you said is not reasoning, but then he has given some reason. It's not that he has not given any reason.
No, he has given, Lordship.
He has given
Lordship,
some reason, may
Well,
not be
I was
elaborate.
only
Lordship, I have just given a detail
Just
about the
just-
arbitrator, Lordship, a little bit, Lordship. Para number 4 of my affidavit, Lordship. The appellant herein has alleged that Honorable Arbitrator, late retired M. Goswami, has passed the arbitral award without considering materials on record. Lordship, I just want to give a gist about the arbitrator, because the arbitrator had been appointed by the Guwahati High Court. It's not that Union of India had objected.
It's not a question of regarding the appointment of the arbitrator. The award must reflect the mind of the arbitrator.
Yes, Lordship.
Now, first claim was, say, 22 lakhs 94,000. This is non-payment of escalated price of labor and fuel. Now, amount claimed is this, amount awarded of 19 lakhs. Now, what is the basis of this? What is the basis?
Award condition. That is claim number 1, Lordship.
Yes.
Lordship, here the initial part of the starting part of the award, Lordship, the arbitrator has in detail discussed about clause 63 of the IFW
No, clause
2249.
63 says that in case during the continuation currency of the agreement, there are prices of certain materials
Prices,
increase.
yes.
Then they will, to the extent pro rata basis, they will increase the price.
Yes.
Now, for that, you have to show, demonstrate to the arbitrator, this was the contract price. The price of these items have increased. These are the government notifications. I made a demand. They have denied this.
Yes, price
Now,
escalation I had
please,
submitted,
please.
Lordship.
Now, come to the finding of the arbitrator. Now, coming to the increase of cost of steel, fuel, and iron rod. This is the claim.
Yes.
I agree that the contractor must submit two very vital documents. He agreeing with this to the department while claiming the escalated cost. They are government notification escalation of cost and the proof of payment towards increased cost. I have gone through the case law submitted. Having gone through the judgments, I have come to the conclusion that in the present case, the principle is not challenged or denied. But however, a claim on a share must be borne by absolute documents. I cannot accept government view in this case. A contractor cannot claim escalation just because he has not been able to submit as alleged any statutory law. For me, has to be seen from any document which proves the cost of relevant materials has increased during the currency of the contract. The document produced before me, I have to accept that there was an increase in the cost, though may not be supported by the last detailed documents. I consider the claimant is well entitled to be compensated for this.
Escalation of
I, however, can't accept the alleged deduction made by the government towards contractor bill in toto to be paid. Now, this is kind of an ad hoc award. See, when you submitted the bill, the learned arbitrator has come to a conclusion that when you have submitted the bill, you have not submitted the government notification on escalation and the proof of payment towards increased cost. This was admittedly not given to them. Now, this you produced during the arbitration proceeding. And then the arbitrator found that these two documents are not foolproof. So, this kind of award cannot be there. He has to come to a finding. He has to assess. You may have a case, but he has to say, because in a section 34 of the code, although we are not reviewable code, but they must know, they have a right to know that on what is the basis of 19 lakhs. No basis is disclosed. He has to disclose a basis. Why not 5 lakhs? Why not entire claim? Which documents he has taken into consideration? Which document he has taken into consideration for this? So there is no specific indication to that. One. Now come to cost towards idle labor and duty extension. Arunachal. I feel rupees 18 lakhs. His feeling will not do. What is the basis? He has to disclose the basis. I feel. Suppose I feel in this court that he should lose the case and you should win. But can I say, I feel after hearing both the parties that he should win and you should lose?
May I please, Lordship? In this para, Lordship.
Just like that.
Lordship,
He is fairer than you, so he should win, he should lose. What kind of this?
No, Lordship. There is a detailed part, small,
No,
minor.
see. This
Let me
cannot
read
go.
this.
See, this is not the thing.
Yes.
Please agree to a fresh arbitration.
My lord.
These claims will go to the fresh arbitrator. Let him decide. In the meantime, whatever the amount they have received, they must keep it in a fixed deposit account.
Lordship, upon arbitrator, we have no
This
difference.
is completely.
We have to go for appointment, Lordship.
No. Here we can. Of course, the latest judgment has to be seen. If you consent, then we can. Otherwise, it is a fresh arbitration proceeding. That a latest judgment.
Idle labor due to extension, Lordship. That portion, actually, I did submit all the registers because we have to maintain a register
It
of
has
the
to be-
labors.
See, the arbitrator has to apply its mind. He cannot just say.
No, he had accepted that. That is written
No,
there. It's
he's not
written,
a-
Lordship. It's
He has
written.
reduced it. You see, even if for you, you are also entitled to know why it is not 20 lakhs, why it is only 18 lakhs.
That portion is different, Lordship, regarding.
However, I accept the condition respondent that the engagement of the labor is to be backed up with documentary proof.
Yes.
Now, this documentary proof is in
In
this
this
regard, the
regard-
claimant submit the daily attendance register where the number of labor engaged on the day-to-day basis have been indicated. The attendance register was signed. I have stated it is too late to deny. Very well, let you deny, very well. Having come to this conclusion, consider the element of labor cost in any engineering work. How much you have paid during this for the idle labor? You have to show that this much of machinery and labor I have kept in expectation that I have to conclude the work. At the same time, you have to also show mitigation of your damage. If you find that for some reasons, then how you mitigate it? You have to show that I have another contract where I could have deployed these persons and I would have earned this much of profit.
But, Lordship, this will be injustice on my client from 2018. First of all, 2008.
No, the injustice, also
Contract
injustice
of
to them because
2008.
they do not know what is the basis of this award.
Lordship, they very well know. They never contended anything against before the arbitrator, Lordship. They never
No, that is
raised
why you
any
want to know the
objection.
statement of claim and the
These objections are coming now, Lordship. They attended the arbitrator proceeding.
attendance means that I am acquiescing to the entire thing
No,
what
no,
has been
Lordship,
done.
they had contested with all documents. They had come
That has to
forward.
be a reflection that for these reasons, I am not accepting this evidence. We must, in a section 34 code, must come to know what is the reason, basis. What do I get the basis?
No.
Case. Please give the judgment of the Supreme Court where the latest judgment, 5-judge bench judgment of the Supreme Court. Normally it is go for, you can seek a fresh reference on this dispute.
Yes, ma'am.
And then we have no power to modify, excepting there are few situations where the Supreme Court, the Honorable Supreme Court let down, where it can be severable, where the part is severable.
Yes, ma'am.
So what we do is like to do is this, that we accept your submission to the effect that this award seems to be unreasoned. On the basis of the same pleadings,
Yes, ma'am.
on the basis of the same pleadings and the evidence,
Yes, ma'am.
if the parties want to adduce any further evidence, they may be allowed.
Ma'am.
And this will be a consent order then, has to be.
Yes, madam.
And on that basis, we may request an arbitrator to conclude the proceeding within 6 months, maybe.
Madam.
Original,
All pleadings,
everything original, before which we had submitted.
all pleadings,
All
all evidence should be there. The
Lordship,
part,
evidence was not there. Let me tell the truth. It went on documentary because none of
No,
the
you
parties
agree to
came
a-
up with evidence.
Now, so you agree to a documentary evidence,
Yes,
correct?
yes, we
So
agreed
no
to
oral
that.
evidence is required. It will start from the stage of. So we'll record that the parties are not inclined to grant any oral evidence. So the arbitrator shall decide the matter afresh on the basis of all the claims on the basis of the documentary evidence.
Losses are referring to the judgment of ISG Novasoft Technologies.
A 5 judgment decision.
It talks about severability of the awards, my lord. Just take out. ISG Novasoft. It's a 25 days.
A2.
Page 277. ISG Novasoft.
Mr. Counsel, this is one thing.
Yes.
Please take instruction. Instead of sending it to be fair to both sides,
My lord.
you find out a claim on escalation. Now that they have given certain documents before the arbitrator,
Yes, my lord.
and it is governed by Section 63, or rather, your term clause 63.
Yes, my lord.
Take a fair stand that on the basis of escalation, these documents, how much they will be entitled to. Because for this escalated price, because even if your own communication, instead of sending it to another arbitrator,
My lord.
because according to your own estimation, you said you write back to us the letter which your friend has shown to us.
My lord.
Write back to us, admittedly, dues are there.
My lord, what I would propose, my lord.
Had it been not an arbitration court, I would exercise my other jurisdiction to bring about a solution to it.
My lord, what I was proposing, my lord.
Should I do one thing? Should we do one thing? It's possible.
My lord.
We send this you to mediation.
My lord, what I was proposing, my lord. Only claim number 6, your lordship kindly looks into account. The loss of profit, my lord. Other claims I'll abandon, my lord. I have instruction to do that.
No, that will be again injustice to me.
The loss of profit is without any basis, my lord.
Profit, Lordship, a work of 18 months, they had dragged me 2012-15 last.
Even for the loss of profit, there is no reasoning given.
Yes, Lordship.
Absolutely no reason. I'll just place one reason, my lord. Unibrow Supreme Court said, my lord, the Honorable Supreme Court.
You have to have a basis for calculating the claim. Have a basis. Why it is not 1 lakh? What is 15 lakhs?
Maybe, Lordship, at that
See,
point,
for
they had
every
given
damage,
something, I don't
you
remember
can have
now.
a notional damage. For every breach, you have a notional damage. You can have an aggravated damage. It depends.
It depends, Lordship.
So, how do you know that loss of profit you delay would be? Suppose there is a delay. How much loss you have incurred? How it is assessed? What project you had at that point of time? Where provided you can utilize this. We have in a recently judgment we have discussed in Calcutta High Court. I delivered the judgment on the profit and profitability. So these are the things which you have to assess.
Yes, Lordship, I understand.
So this 6, what he says, to put a hiatus to this, if he is agreeing to this up to 4 and 5, then I think you should accept this. Otherwise, at the end of the day, we don't know where it lead to.
Lordship can give me a little bit time more to go through everything. Whatever proposition also Lordship had said, going to another fresh
Because if you have to go by the each head, then well,
I know, I understand. At least I need to talk with my client also.
you talk to your client.
Yes, he
But at the
is
same
also
time, at the same
80
time, you
years
see,
old.
no.
and
You see, you got your
I
one.
don't know how
You are
he
you are in a
thinks.
lucky position that you got 1 crore 4 of a contract of 99 lakhs. Most of the cases, it not even received 10 lakhs and they fight for 20 years. So here they were generous in a sense that they paid you 1 crore 4 lakhs.
And 50% of the awarded amount also.
50% of the award
They're
amount
enjoying
you have
that
also received. So on escalation, you take a call on this.
Well,
whatever documents they have supplied before the arbitrator, on the basis of it, what would be the estimated amount?
Well,
Is one. Of course, there is a prolongation of contract,
yes, my lord.
and there has been some delay on your part.
Yes.
So if you accept 18, I think we have nothing to say on that.
And
Rent
if-
for
if-
machines
if
is
they
entitled
accept-
to.
If they accept 6, my lord,
No, they are accepting it. This they are accepting. They are not denying this. There is no cross appeal before us. Setting aside by you only.
my claim number 6, the loss of profit.
No, I'm coming to that. 3, you cannot escape.
Yes, my lord.
3 is already there.
Yes, my lord.
Escalation against material for delay caused by the department in completion of the contract. This escalation, in fact,
Though there is no calculation, but maybe
no,
maintainable.
this escalation, in fact,
Yes, my lord.
would come in claim number 1 itself. Because non-payment of estimated price of labor, fuel and material is covered in 4 and 5.
Yes, my lord.
There will be two part of it, you see. One escalation is during the, you just calculate this way. One escalation during the subsistence of the contract.
Yes, my lord.
And one escalation post subsistence of the, post the contract period,
During the extended period.
extended period.
Yes, my lord.
This you calculate,
My lord.
come with the calculations on this claim number 1, claim number 4 and 5. And also cost towards delay in Schedule B stores, this will also have some basis.
Yes.
You see, madam, the difficulty I tell you that you are now being so vocal.
That too had been
No, no,
already
this
tagged up.
is a vocal. Amount claimed was, we don't know how much. So far as cost towards delay in issue of Schedule B stores, here it says this 70 lakhs was claimed including delay in Schedule B. So it's a composite claim of 17 lakhs. You have been awarded 11 lakhs.
Yes.
Here the arbiters, I agree that there were element of negligence on the part of the contractor also sometime, but I can accept the extension totally wipes out the claim of compensation. There has to be some basis, madam. It cannot be at the ipsedixie of the arbitrator. Delay, yes. How much? If both sides are they have contributed to the delay, then no. No, ordinarily. Delay in handing over the site is already included in your other claims.
Yes. That's true. Actually,
So,
things started
so
from there only.
basically, claim number 6, in other way round, is inbuilt in your other claims. Think over it and come back.
Lordship, even I can do a calculation based at that period because I already have all every details which I had submitted.
No,
before
both of you can sit together and have a joint calculation sheet
we
prepared
can
and make it.
prepare something like that
Yes.
best for the court.
Whatever is legitimate, we can, provided we cannot do this, in a sense, unless it's a consent thing.
My case was only, my lord, if they accept claim number 6 to set aside. my
I
lord.
think you should accept.
Others we
I
are
think you
fine.
should accept 6 because 6 is inbuilt. Because if you tinker with 6, your 4 and 5 will go.
I understand.
Both
Lordship.
sides, is both sides contributing, then of course,
Time may be given a little bit. I'll sit down with him also because again we have to arrange. I come all the way from Guwahati.
no, I understand.
No, I'll have instructions of the department.
First, he will talk with the department.
And we'll come out with our own calculation.
No, I agree with your claim number 6.
Well.
But you see, at the end of the day, what we are worried about
Like it.
is not your money or my money, it's a government money, exchequer. It's a public money at the end of the day.
Well.
So you have to be, whether you consider or not, that will not cut much ice with us.
Well.
Because it is a government money. We should look into the government exchequer.
Yes, ma'am.
Lordship,
So, but at the same time, whatever is due to them legitimate, that can be, that they should get it. So, your letter of prima facie, what we feel is this, that on the escalation they have a case. may not be there, not so much of reasoning may have been given. If you apply contract clause 63,
Well,
then they are entitled to.
yes, well.
Yes, Lordship.
Now they will be entitled to both during the currency and the extended period.
Yes, well.
You make a fair calculation of it.
Well,
We leave it to you. You are the additional Solicitor General. So
Well,
we'll have full faith in you.
well,
That is a bona fide claim.
well.
Correct? I'm not saying other claims are not bona fide. That's a legitimate claim. Let us put it this way. Now, because of the prolongation of the contract, so the idle labor, if there is a proof of idle labor,
Yes, well.
and there's a delay beyond their control, some amount of compensation, if you agree with 18 lakhs, 18, possibly documents may speak for it, 18 lakhs.
Well,
1.5 they are entitled to. There cannot be any doubt on this. So far as 4 and 5 is concerned, there is, according to the findings of the arbitrator, there is both sides are negligent, they are also negligent.
yes,
So 17 can be reduced to 50% of it,
yes, well.
which may come to say 8 something.
Yes, well.
So this can be 8, 6 can be wiped off, others may remain.
I'll have it. Well.
And if you find that this 19 lakhs should be a fair estimation on the basis of the documents they produce, I accept it.
Well,
So as of, please madam, take also instruction. 1 would remain as it is. 2 would remain as it is. 2 would remain as it is. 3 would remain as it is. 4 and 5 will reduce it by 50% and no 6.
well.
I think that will be fair.
Lordship, claim number 7 was wrongly interfered because this is double deduction.
Yes, 7 is wrongly interfered.
7, wrongly.
But you have no cross appeal, but then again,
Yes, Lordship. But that has been, I had showed
there's
before
no
the trial
cross
court
appeal,
also.
but
I'll have it. Well.
please, I think this like to have both of, because we have our limitations
Yes.
because of the law laid down by the Honorable Supreme Court. So either we set aside or we upheld, and we separability part is there. Which part is severed from the other? Separability.
Yes, well.
So if you find a joint petition there, it would be easier for us to decide.
Well,
Otherwise, we have to find out the means. Okay.
we will try to settle it now ourselves.
This will be the modalities.
Yes,
November, Lordship.
Sorry.
Next date, Lordship, November.
yes, no.
No, you have to tell us the date.
Lordship.
Please give us the date.
12,
Yes.
12, 13, 14, that is okay.
I don't want Monday. Monday, traffic is very
No,
high.
you please tell us, madam, since you'll be outstation, and also your availability.
12, 13, no.
12, 13.
Should
13.
we keep it on 12th? Should we keep it on 12th? Madam,
Lordship.
should we keep it on 12th?
13, Lordship. Thursday.
13th there will be. 13th we have that at what time? Not in the morning, I believe.
Lordship, 14 then.
No, this 13th, 14th there's a problem. 11, 12. 12 will be a problem for you, madam.
I have trial court matter in Guwahati.
Oh, I see. Okay. Before that, no, before there's a holiday. Very well. Then can we keep it on 18th?
Again, trial court matter, Lordship. That's it. Then, Lordship, 17th Monday.
17th, no, we are returning. Better if it is on 19th.
Oh, no, Lordship. Full of trial court matters, all evidence, Lordship. I won't be able to leave Guwahati.
You address me on virtually, no problem.
Lordship, anyway, then, Lordship, the next and the last week in 24th, Lordship, 24th is Monday.
Yes, 24th can be.
Yes, Lordship, 24th.
We have heard the land counsel for the parties. The matter is adjourned.